DC judges reject presidential immunity for Donald Trump, and nobody's surprised about this. We all knew this was coming. Why? Because we heard during oral arguments some of the bizarre questions from the judges who were saying things like, can Trump murder everybody in Congress? Relax, ladies. So these were the judges who were actually behind this ruling, and we're going to see what they wrote in their 57-page opinion that came out of the DC Circuit Court of Appeals. We're going to talk about timing, about when this trial is going to happen, if it is going to happen before the election, as Jack Smith and the Democrats really want. We know they're freaking out to get this back on track. We're going to get reaction from Johnson and others, including Trump himself. But before we dive into the actual opinion from the judges, our friend Julie Kelly over on X at Julie_Kelly2 on the X platform, she says, just so you're aware of who we're talking about, a lot of these judges like to hide behind their robes, their gavels, and their closed down courtrooms. But here's the people that we're talking about. The first three judges were appointed by Obama and Biden. Okay, so Judge Chutkan, you know her. This is the other judge who's on the bench, and this is Judge Pan, I believe, also on the bench, all appointed by Obama. You know, that's what they look like. Now, the other judge has been on the court for 34 years, this woman, and she was appointed by Bush, and she's actually older than all of the other Supreme Court judges who are there and in the Supreme Court. All right, so like been around for a long time. So they took about a month to draft this opinion. They listened to oral arguments, and they came up with their conclusion that Trump is not immune. And so we're going to go through that. We're going to jump back out and refresh our recollection about what the actual question was, because in this opinion, there's going to be a lot of arguing around the point. Like they're going to make a lot of arguments. It's all going to sound good, but that's not what we're actually talking about here. And we've seen a lot of this with the Trump stuff, and it's pretty bad legal crafting. But I think what, honestly, if I can just for a second think about this, why are they doing all of this? In other words, they're breaking standards. They're setting bad precedent. All of this is for a reason, right? It's to stop Trump. There's this unspoken rule that's happening throughout all this litigation, especially these appeals. It's that this is not going to happen again, okay? We're not going to have another president come through our courtroom again. We're not going to lose control again. So we're going to be willing to break and bend and maneuver all of these rules, all of this precedent, because it's only for Trump. As we say here often, it's break glass in case of emergency, but we're not going to have another emergency because we're never going to lose control of the presidency again, okay? They'll shatter this and they'll say there's not going to be that many consequences to the executive branch because we're never going to be here again. But we're willing to do whatever it takes now, right now. Now, nobody's going to say that openly. Nobody's going to say that in public. You know, these are supposedly accomplished judges, right? And supposedly they're, you know, credentialed and they deserve to be where they are. But that's the only explanation for this, is they're breaking the rules because of Trump. All right, let's get into the opinion. Without any further ado, here's what it says. United States Court of Appeals, District of Columbia. Case, of course, as we know, the U.S. government, Joe Biden versus Donald Trump, using the DOJ as a political tool against his enemy via Jack Smith. It's a 57-pager. We're going to hit the highlights. We remember John Sauer, and we have a clip from him. He was the person who did the oral arguments back when they were before the court. Now, quick note on this. Those judges, those three judges, right? It's not the full Court of Appeals. Trump will have an opportunity to resubmit this to the full panel. It's called en banc. He could say, yeah, we're going to go to them and we're going to see if we get a different outcome. Probably not. Maybe he'll do that. Maybe he won't do that. Maybe he'll just take it right up to the Supreme Court. We don't know. But the point is, you know, these judges are supposed to stand for something, right? I mean, they're here, they're saving American democracy and all of this stuff, and they're concocting this opinion, but they don't have the courage to even sign their names to it. You'll notice that. Here's the opinion for the court filed per curiam. It's the opinion of the court. Okay. It's just the opinion of the court. Nobody signed it. You normally see something like this. Now it's before these judges, Henderson, Childs, and Pan. Normally you'll see Henderson, with whom Childs and Judge Pan join, right? Or this person joins and this person dissents, with whom this person joins, right? But they didn't even sign their names to this, right? Not even sign. It's just pure curiam. It's just the opinion of the court. What's up with that? If you're going to be, you know, enacting historic precedent, don't you want your name behind it? Or the answer is no, right? Because they know this is not good law. They know that they are breaking glass in case of emergency. They just have to write this just to stop Trump, okay? But if this was reconcocted, if this was brought against Joe Biden or brought against Barack Obama for executing American citizens, or Biden for causing an invasion at the southern border or whatever, there would be a strong defense of the presidential actions. But they are, you know, it's kind of like when you stab somebody in the back, you don't want anyone to know about it. So just pure curiam. This is a good opinion. It's really good law, but we're just not going to sign it. So nobody knows who actually wrote it, and it's not anchored in on my record in the history books. Okay. So they write, per curiam, bunch of weenies, says Donald Trump was elected the 45th president. He was sworn into office. We know that. And his term expired on noon. Now, at that moment, they write, President Trump became former President Trump. Wow. Now, although the sequence is set by the Constitution, it did not proceed peacefully. From Election Day 2020 forward, the government alleges that Trump denied that he he had lost his bid for a second term, and he challenged electoral results. There was a rally held on January 6th. The rally was headlined by Trump, and there was a breach at the Capitol. And the breach, this so-called insurrection, they even admit in this circuit court, it delayed the congressional proceedings for several hours. Wow, several hours. And it was not until the early morning of January 7th, which was like midnight, okay, big deal, that the results were certified and Joe Biden was sworn in as the president, soon to be president, confirmed. Thanks for that. Now, since then, hundreds of people who breached the Capitol have been prosecuted and imprisoned by their political enemies. And Trump was charged with a 4-count indictment as a result of his actions. Now, former Trump moved to dismiss the indictment, and so we're going to pay close attention to this. What are we talking about in this filing? It was a motion to dismiss, and the district court judge Chutkan denied that. Today, we affirm Chutkan's decision. Now, for the purpose of this criminal case, former President Trump has become citizen Trump. Now, this is an interesting statement here. With all of the defenses of any other criminal defendant, but any executive immunity that may have protected him while he served as president no longer protects him against this prosecution, which is a wild thing to even, to say that, because it's like the actions that they're charging him with crimes over, he was the president at that time. Okay, he didn't commit a new crime. He didn't leave office in January 21st, and then go commit a new crime. In this case, the allegations are about January 6th, when he actually was the president, and he actually did have control of the government, and he did have a duty and an obligation to make sure our elections aren't rigged. So what they're acknowledging is apparently they're stripping him of that prior, we're just saying we're taking him out. He's no longer the president, so we don't have to really think about that. Now, I want to also pay close attention to this, because what are we talking about? Yes, this is Trump's motion to dismiss, certainly. And so what standards are we applying to this? Like, what does Trump have to show the dismissal? And the basis for the dismissal, which is going to add another layer to this, is immunity. Okay, so it's not motion to dismiss because of a corrupt prosecutor, like maybe we see in RICO case in Georgia, or a motion to dismiss because there's no evidence, right? They lost the blood results or something. It's a motion to dismiss because the president is immune. It's not necessarily a problem with their case, but it's that the president has immunity. And that's kind of a separate thing than a regular, just generic motion to dismiss. So how are they treating this? Are they treating this as a motion to dismiss, affirming that we've got immunity, and then applying a new immunity standard? Or are we applying a motion to dismiss standard? How are we measuring? What's the measuring stick against which we are proceeding? So let's see what the court tells us. Here's the background. They say Trump did not concede 2020. His supporters made numerous attempts to challenge the results. Many attempts were allegedly criminal. Allegedly. Yeah, from Fannie. Now, a DA, a District of Columbia federal grand jury, returned an indictment. We know the 4 counts. And of course, as you'll note, let's just confirm this, not a single insurrection charge amongst them. Conspiracy to defraud the United States by overturning the election results. So a conspiracy to defraud. Another conspiracy to obstruct an official proceeding. Okay. Obstruction of the official electoral vote count. And a conspiracy against rights. Section 241, to have their votes counted. All of these were just conspiracy charges, right? And the things that they're alleging, the conduct, like what is the conspiracy to have their vote, saying you tried to take away people's votes. Why was that? It was by him enforcing the rules, saying, were those votes counted? Did you have the signatures? In other words, leading the investigation. So they're saying that all of that conduct is criminal. Now, we emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain the convictions must be determined at a later stage of the production. But here is what as I backed up, and we're talking about these standards, right? The motion to dismiss the indictment. So what they're doing is they're going to say, at this stage of the prosecution, we kind of want more there. What stage? At the motion to dismiss stage with an immunity provision, he says, we assume that the allegations set forth in the indictment are true. We're just going to presume that whatever Jack Smith said is true. And you might say, well, that sounds problematic, and it could be problematic because, again, we don't really know what the standard is. Like, what's the measuring stick? We don't know. But think about it this way. Like, if someone's going to file a motion to dismiss against you, you want the benefit of saying, well, if they're going to move against me, they need to show that even if everything that I said is true, they would still win. Then you could dismiss my case. In other words, we hold the non-moving party in a light most favorable to the non-moving party. So since Trump is moving to dismiss it, they're going to say, okay, well, let's say that everything that Trump says, everything in the indictment is true. If Trump still merits a dismissal in the aftermath of that benefit of the doubt, then we'll dismiss it. And immunity would actually do that, right? Everything Jack Smith said is true. That's fine. Trump has immunity. It's just like self-defense. It's like, yeah, I punched the dude in the face. Yeah, I broke his nose. Yeah, there's blood all over the place. Not happy that he's unhappy with that. That's true. But I was privileged, right? I'm immune from charges because I was acting in self-defense. Same concept. So the indictment here alleges that Trump understood, which they're going to have a hard time proving that. I've never got that sense, that he had lost the election, but nevertheless that the results were legitimate. And he knew that the results were legitimate, but nevertheless he was determined to remain in power. He then conspired with others to cast doubt on the election outcome to contrive himself to be the winner. Now, the indictment charges that he and his co-conspirators used 5 primary means. 1, false claims of election fraud. So they said, we have an opinion that the election was rigged rigged, and they said, you can't have that opinion. And they said that there were statements they went through. 10,000 dead voters voted in Georgia, 205,000 more votes in Pennsylvania, 30,000 non-citizens in Arizona, right? So they were, I guess, spreading misinformation about this. Second, then Trump and his co-conspirators, then they organized fraudulent slates of electors, which we've seen in prior elections, like I think 1960 back in Hawaii, when they had alternate electors. So then they caused the fraudulent electors to transmit their certificates to VP Pence, which again, you would do if you were anchoring in your party's position, right? Just saying, hey, we're going to contest this. This is our slate. It's an alternate slate from the party. We're challenging this. Third, then Trump and his co-conspirators, then they contacted DOJ officials. They said, hey, can you investigate this stuff? And they said that there were false claims that the DOJ had identified concerns. And then fourth, that they put pressure on Mike Pence to encourage him to undo it. And then fifth, of course, was the icing of the cake, the J6 rally. So then Trump, he made efforts to overturn the Constitution, and there was an impeachment that took place. Now, 9 days before Biden's inauguration, the House adopted an impeachment resolution under Nancy Pelosi called incitement of insurrection, the same allegations that are happening here in this case. Now, the impeachment resolution, it asserted that Trump repeatedly issued false statements about the election, and they tried to impeach him on that. But he was acquitted. Now, by the time the United States conducted the trial, he had become former President Trump. Now, at the close of trial, 57 senators voted to acquit him. And because 2/3 of the Senate did not vote for conviction, he was acquitted. But they're going to say that doesn't really count, right? They're going to say, well, some of those senators, they voted to acquit him on other reasons, and so they all didn't have the same reason, and so we're not really going to count that, and the impeachment judgment clause doesn't apply. On November 19th, then U.S. Attorney General appointed John Smith as special counsel to investigate all this, and of course, we got an indictment after August 1st, 2023. So Trump is here. Now he's saying a bunch of things. One, presidential immunity, constitutional provisions like the impeachment judgment clause and double jeopardy prevent him from being charged again. He's already tried on this in the Senate. He was already acquitted. We just gave the checkbox right here. Boom. He was acquitted on that. So how are they trying him again? On December 1st, the district court, Shutkin, rejected all of his claims, saying that there's no way that a president could be exempt. Trump filed a number of appeals, and here we are today. Now, the court is going to give us some jurisdictional stuff right here. Now, former President Trump and his two arguments, they can be analogized to constitutional immunities, which these other cases require. Now, his separation of powers argument does not explicitly draw on speech or the debate clause like they did in those other cases, but the immunity for official acts that Trump asserts is closely akin, so they're trying to analogize this to another case, closely akin to a speech or debate clause. So this is really the type of immunity that Trump is trying to claim, and they've got this other case law that kind of matches that. Likewise, Trump argues that the impeachment judgment clause incorporates a double jeopardy principle, right? How can you be tried twice for the same offense? And Trump was acquitted in the Senate. Now, we found a similar line of reasoning that's convincing in this case. If a treaty provision mirrors the double jeopardy clause, so does a constitutional clause that attaches jeopardy to the impeachment acquittal. Now, both of former President Trump's arguments are at least analogous enough to the speech or debate clause and double jeopardy to fit within our precedent. Accordingly, we conclude, okay, this is the jurisdiction section, that we have jurisdiction to reach the merits on the appeal. Okay, so they can hear the case, fine. Now, for all immunity doctrines, the burden is on the official claiming the immunity to demonstrate the entitlement, right? Now we're talking standards. Here, former Trump claims absolute immunity from criminal prosecution for all official acts undertaken as president, a category he contends includes all of the conduct alleged in the indictment. So that is a little bit overbroad, isn't it? I think it is. So that's kind of not what he's saying exactly. So all official acts, well, I guess that is true. Now, the point here, they're leaving out a little parentheses, right? They're leaving out the point where the Congress has a check on this. They like to use this talking point that Trump claims he can do whatever he wants. He has absolute immunity. Well, sort of, but Congress can eliminate that, okay? Like absolute immunity subject to Congress. So it's not really absolute. I mean, it's pretty close, but if Congress impeaches you and convicts you, then that is shattered, okay? So it's not really absolute immunity. Absolute to me means nobody can take it away from you. There is a mechanism to take that away from you. Very easy. All Congress has to do is impeach you and convict you. And by the way, that is a normal process in law. Happens all the time, that you have safety proceedings to make sure that there is actually teeth there before you move something forward. For example, before you can be indicted with a crime, they got to show probable cause. We know this, right? Before you as a regular citizen can be charged, cop has to think there's cause there and write a direct complaint against you and arrest you. Or a prosecutor needs to indict you, present the case to a grand jury and show that there is cause in order to take it to the next step. So the same thing applies to the president. And this is a political safety safety valve. It's a safeguard. The president needs to be impeached and convicted. And by going through that process, we know it's not political because there's a 2/3 majority. Even the president's own party, his own supporters are saying, okay, this dude's a criminal. So it's not absolute immunity. So this is, I think, overbroad. They just make that the argument. And that's not the argument. It's much narrower than that because we heard that even from D. John Sauer. This is the attorney on Donald Trump's team who is arguing this very point. Question from the judge, Judge Pan. Can he execute his political opponents? Here is what Sauer said in response to this.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, as long as it's an official act. I mean, certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that so long as he's not in office.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
But if he weren't, there would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is
yes.
No.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders were much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted?
Requirement.
And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first. We may be saying the same thing.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a
She just changed her question.
Rival. Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not.
She just changed her question.
Says that.
Okay, so she just changed her question because she didn't like his answer. So then she threw in some other stuff. So she was trying to get an answer that she wanted. She didn't like his answer. She wanted him to say no. He didn't say no, but they respond as though he said no. They claim absolute immunity. He didn't say that. He said immunity subject to impeachment. But here's where they're going to continue to just argue for points that no one's making. So they say the question of whether former President Trump enjoys absolute immunity from federal criminal liability is one of first impression. That's not his argument at all. Okay. It's a qualified immunity. Okay. It's not absolute, meaning if he gets impeached, it goes away. Noting that the unresolved question of whether or when a president might be immune from criminal prosecution. Says SCOTUS has consistently held that even a sitting president is not immune from responding to criminal subpoenas. And in the civil context, the SCOTUS has said that a former president is absolutely immune from civil liability for official acts if those are within the outer perimeter of his official responsibility. Okay, so that's civil stuff. So the president has absolute immunity from civil liability for his official acts, which is even broader than this because, arguably the impeachment judgment clause doesn't apply to that. Both sitting and former presidents remain civilly liable for private conduct, okay? And when considering the issue of presidential immunity, SCOTUS has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions. Now, former President Trump, he claimed immunity would have us extend the framework for civil immunity to criminal cases and decide for the first time that a president is categorically immune from criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility, which is true, but he's still subject to, that he could be charged. Like they just leave that out. It irks me. He advances 3 grounds for establishing this expansive immunity. Now, here is where they finally get to it. Article 3 courts lack the power to review his official acts under the separation of powers document because they're substituting their judgment for the president's judgment. They're saying, well, you can't do that or you can do that, but that's not their judgment. Otherwise, the courts become the president. If the courts can dictate to a president what he's allowed or to do or not do, then the court is the president, right? In many ways, especially for issues that are their official acts. So they say, number 2, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions. And then finally, that the impeachment judgment clause does not allow the criminal prosecution in the absence of Congress impeaching him and convicting him, which was a main point of their argument that they forgot in all of these other paragraphs paragraphs. Thanks for finally acknowledging it. Now, our analysis is guided by the Constitution. Yeah, right. Relying on these sources, we reject all the bases for Trump's immunity. Now, they're going to give us some background on this. All right, separation of powers, saying the Constitution is important and the president occupies a unique position. Tell that to Judge Chutkan. Now, under the separation of powers, the president has executive power to take care that the laws be executed, which includes making sure our elections are not rigged. It's settled law, separation of powers in here. They say, nevertheless, look, Trump argues that the constitutional structure and the separation of powers means that neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts, because they're the president's acts alone. They can, but the mechanism in place to protect the presidency against those things has to be overcome. He relies on Marbury, but they say, sorry, Trump misreads Marbury. If you properly understood Marbury, they say the separation of powers doctrine, it may immunize lawful discretionary acts, but it does not bar the federal criminal prosecution of a former president for every official act, which again, they're not making that point. They didn't say that about Marbury. Marbury distinguished between two kinds of official acts, discretionary and ministerial. Chief Justice recognized a lot of this, a Marbury case law here. And then in Mississippi, there was some more law. Then the Supreme Court exercised some stuff over steel mills. Now, objections were made in the history of Marbury, and the Supreme Court has repeatedly affirmed that the judiciary has the power to direct appropriate process to the president. But the president does not enjoy absolute immunity from criminal subpoenas. We have that case that supported that one. And so the separation of powers doctrine, summarizing all of this, as expounded and its progeny from Marbury that they just educated us about, it necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's laws. Now, although certain discretionary actions may be insulated from judicial review, they say if the allegation is that the president violated Congress's laws, then I guess that pulls him out. That's all you need. Here, we finally get some application to the actual case. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not within the scope of his lawful discretion. And so, therefore, Marbury and its progeny provide him no structural immunity from the charges in the indictment. Crazy! This is crazy. So this means that any prosecutor can just shatter and just change the category of these things just by filing criminal charges. So there goes the presumption of innocence, in other words. If a prosecutor just says, allegedly, you acted in defiance of congressional laws, then that gives everybody power over the president because they said you violated the laws. And so therefore, you must be not in coordination with Congress. This is crazy. Trump's actions allegedly violated this. So he just gets, there you go. It's just outside because a prosecutor filed it. That's their conclusion. Now, our conclusion that the separation of powers doctrine does not immunize former presidents is reinforced by analogous immunity doctrines. Legislators and judges are absolutely immune from civil suits for any official conduct, and legislators have explicit constitutional immunity for speech and debate, but they can be criminally prosecuted under generally applicable laws for their official acts consistent with the separation of powers doctrine. But they are not the president. Oh my gosh. Legislators have explicit constitutional immunity, but outside of constitutionally protected legislative conduct, they also perform a bunch of case law again. Anytime you see me fast forwarding with all of these italicized cases, they're just explaining cases, right? It's a lot of filler. Just think of it as filler. We have a basis for doing this, and here's the case law to settle it. Here's most recent case law on judicial immunity, which again is not really, they're analogizing. So let's see how they apply it to Trump. All of this is case law. We therefore conclude, there's not much application here, right? We're seeing just a lot of copy and pasting here. So just as a backdrop, okay, anytime we analyze these documents, just so you're aware of what I'm looking for, in general practice, okay, the way opinions are organized are in the IRAC format. We talk about this a lot here, IRAC. You have an issue, you have the rules, you have the application, and then you have the conclusion. They teach you this first year of law school. And it's a good way to organize your thoughts. It's a good way to organize your writing. So the issue, is Trump immune? Here are the rules, bunch of rules. The rules are as follows. We explain the rules, and you might even, some people call it IREAC. You put an E in here, IREAC, right? An explanation of the rules for better legal writing, a little sub-E there. But then you apply it. Then it's your analysis. You apply the rules to the case. So then we get to some of this. Now, we therefore conclude that Article 3 courts may hear charges in the indictment under the separation of powers doctrine, as explained in Marbury and other cases. Now, this indictment charges that former President Trump he violated criminal laws of general applicability. Now, acting against laws that were enacted by Congress, he exercised power that it was at his lowest ebb. Therefore, former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he's answerable in court for his conduct. And I'm pretty sure that was the analysis analysis for this section here, the analysis and the conclusion. All right. I mean, the rest of this is just explaining the rules. All right. But here, now let's talk about functional policy considerations. Now, even though it is proper under Marbury for an Article 3 court to hear criminal charges brought against a former president, we still have to consider public policy, including our constitutional heritage and structure. Now, we note at the outset that our analysis, this is these people, okay? So here we're going to get some analysis, and this is a public policy position, functional public policy considerations, which we're not really concerned about as much as we are about the Constitution and about the logic of the constitutional order that we're trying to maintain here. But this is what I was explaining at the outset of this entire segment, is that they are trying to create a little escape a hatch, right? This is their little, only in this case. That's why these weenies didn't even sign their opinion with their names on it. We're only going to bend the rules and break glass in case of emergency for this one case. We note at the outset that our analysis is specific to the case before us. And so we're going to stab every, American constitutional law in the back because of Trump. But we're not going to do it again, right? The next time this comes before us, they're going to have to do a different analysis for Joe Biden or for Barack Obama or for whoever the next president happens to be that is, charged with a crime. They'll just shift themselves. We note our analysis is specific to this case before us. Well, thanks, because you put that at the top of the document. Okay, that's the title. That's the case we're here on. Thanks. In which a former president has been indicted on federal criminal charges for a conspiracy to overturn the election. Now, we consider the policy concerns for two reasons. First, possible intrusions on the authority and the functions of the executive branch and the countervailing interests if we allow presidents to be prosecuted. And we conclude that the interest in criminal accountability held by both the public and the executive branch, look, it outweighs the potential risks of chilling presidential action and permitting vexatious litigation. So those three women judges, they had a little balancing test, okay? And so they just put this little fulcrum right there in the middle. And on one side of this seesaw, they put immunity. If we grant immunity to Trump, that's going to protect the president right over here. But the public concerns are over here. And they just weighed these two things out. And they said, since we're the DC judges, we think this side is more favorable. And we just picked that side. And judges do this a lot. We just decided, well, this is what we think. It outweighs the potential risks of chilling presidential action, right? Because all of the other presidents are going to play ball. Presidents aren't going to, do things like Trump. And so there's no harm in us doing what we're doing because there's not going to be any consequences because all of the other presidents will not be Trump. Now, second, we examine the additional interest raised by the nature of the charges. The executive branch's interest in upholding presidential elections. And they say these interests compel the conclusion that Trump is not immune. Now, we do not address any policy considerations implicated in the prosecution of a sitting president or in the state prosecution of a sitting president, sitting or former. So again, they're taking this out of, they're not commenting on Fannie's case. Basically, they're only commenting on this case, not any other case from Trump. So here, they say former President Trump, he argues that criminal liability for former presidents, that it risks chilling presidential action while he's in office. And it opens the floodgates to meritless and harassing prosecution. They say, but these risks do not overcome the public interest in fair and accurate judicial proceedings, which is at the height in the criminal setting. And they just cite some case law for that. They say Trump asserts that the prospect of post-presidency criminal liability would inhibit them from being able to do their job. But rather, again, a bunch of case law, right? The court reinforced this point and all these other cases in Nixon and so on, saying here, if applied to Trump, we cannot presume that a president will be unduly cowed by the prospect of criminal liability. Like they're going to do their job. And the fact that you've got 4 indictments all in 1 year from 4 political hacks is not going to deviate another president, right? This is not going to chill their speech. And also, past presidents have also already understood themselves to be subject to impeachment and to criminal liability. And so other presidents have already acted with this without needing this immunity. Even Trump concedes that criminal prosecution of a former president is expressly authorized after impeachment and conviction, which, okay. So they're saying Trump even admits that he can't. This is so wild. So in the same document, these judges are saying even President Trump concedes that the criminal prosecution of a former president is expressly authorized after impeachment and conviction. Okay. So they get his argument. They understand what his argument is. They're not stupid. He made it at the oral arguments. We just listened to it. But in the same stinking document, as we just scrolled up, I'm not going to scroll up and find it here, but their argument, as we pointed out, was about absolute immunity. But they admit here, Trump concedes it's not absolute, right? All you got to do is be impeached and convicted. So we presume that every president is aware of the impeachment judgment clause and they know that they're liable. And so what does he need additional immunity for? And historical precedent also suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from from criminal liability. Nobody has made that argument. Weird judges? Weird. Okay, here it's like the next paragraph. Additionally, recent historical evidence suggests that former presidents, even Trump, they have not even believed themselves to be wholly immune. That's true. No one's making that argument, but they're using that to like make their point that he's not wholly immune. He's not absolutely immune. They just conceded that, and you admitted they conceded that right here. There's only a safety valve that you got to jump through. It's not complicated. They're talking about Bill Clinton's pardons. They say in light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of other presidents acting on apparent understanding that they could be prosecuted, the risk of criminal liability chilling presidential action appears to be low. Again, twisting themselves to make their point. They're like, well, Trump already knows that he could be prosecuted. Okay, but you just said in your last argument that he's making the argument he cannot be prosecuted. So which is it? Instead of inhibiting the president's lawful discretionary action, the prospect of criminal liability might serve as a deterrent. Now, former Trump next urges that a lack of criminal immunity will subject them to politically motivated prosecutions. But we don't find that's accurate at all. A lot of case law. Here, now President Trump, so this is a good example of an IRAC, okay? So next, right? So next. So when you're reading case law, you're looking for these signposts. Okay, next. So we're gonna have a new IRAC right here. What's the issue? Here's the issue. The issue is that a lack of criminal immunity will subject future presidents to politically motivated prosecutions, right? So that's the issue. What's the rule? In the civil context, here are the rules. Supreme Court said, found, blah, blah, blah. Citation, quote, citation, quote, citation, quote, citation, quote. All of that is the rules, right? So when I was saying these people are just copy and paste, like most of this opinion is just copy paste rules. This is all the rules section. So you have just the one issue, you have the rules, and rules, you know, you can find rules for anything, just to be clear about this. You find whatever you want, just cobble them together, get, you know, these are just little quotes. Courts presume that they, ... properly discharge their official duties. You have like, you know, appellate legal briefers who are like excellent at this. They're just like pulling out cards one after another and just assembling. It's like amazing, but it doesn't really mean much, right? Now, then they jump into their analysis and they say, okay, as former president, Trump acknowledges this is the first time since the founding that a former president has been federally indicted. Now, weighing these factors, actually, that's still a fact. That's not even analysis. Weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions, it appears to be slight. That's the conclusion. So I'm pretty sure we just got, yeah, that's our analysis section there. So there's really not much analysis happening, okay? They're just saying, well, all of this here. Additionally, former President Trump's predictive judgment, there's a little bit of application there. All right. So they're just jumping to conclusions, right? And they're arguing around the point, even in their own document. So on the other side of the scale, we must also consider the constitutional weight of the interest to be served. So it's another mini IRAC. These are IRACs stacked within each other. There's also a profound Article 2 interest in the enforcement of criminal laws. All right. Got to make sure that no one's above the law, right? We heard that phrase. The federal prosecution of a former president fits the case to vindicate public interests, and the risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote. And so we therefore conclude that the functional policy considerations rooted in the structure of our government do not immunize former presidents from federal criminal prosecution. Next section, indictments. The indictment alleges that assertedly official actions that are at issue here were undertaken by Trump, and they say it was done to make him unlawfully stay in power. Now, the alleged conduct violated constitutionally established designs. The 20th Amendment reinforces the presidential term. It's 4 years. The president has a duty to take care, and this duty encompasses a lot, right? The president has a duty to faithfully enforce the laws. This duty encompasses, they say, following the legal procedures for determining election results and ensuring that executive power vests in a new president. So they say that's the president's duty, and you have to do it the way that we do it. Now, to the extent that President Trump maintains, they say Trump can't say that that's all he was doing, right? There's this take care clause. The president has a duty to take care of their responsibilities. They got to do their job, and they have the power to do that, right? To make that happen. So he's relying on that to say, I had an obligation to go make sure the election was not rigged. They say Trump cannot rely on that. His conduct conflicts with the constitutional mandate to enforce the laws governing the process of electing the new president. So again, this is the court substituting their judgment, right? They're saying Trump challenging the election, which he's allowed to do, or was allowed to do until this indictment. He can't challenge it. All he has to do is his duty, okay? The president's duty is following the legal procedures for determining the election results and ensuring the power vests to the new president. And I noticed they didn't cite that. Is there a duty in the Constitution that says that the president just has to just say, okay, I guess CNN called it for Joe. That's the end of the story for us. What's the citation on that one? Is there a citation there? there? Where does that duty come from? Judges? It comes from you. They just made it up and shoved it in there. Now, the public has a strong interest in our government working. Of course we do. That's why we were so upset about a rigged election. The Supreme Court recently noted that the framers said a bunch of stuff about the president. Now here, former President Trump's alleged efforts to remain in power, despite losing the election, were, if proven, an unprecedented assault on the structure of our government. Allegedly, they say, injected himself into a process where the president has no role. He's the executive, and again, this is their discretion, right? Like the counting and the certifying of the Electoral College votes. He wasn't there counting them, thereby undermining the established procedures. Now, to immunize Trump would go further, and Judge Jackson wrote that and so on. And so we cannot accept Trump's claims that the president has unbounded authority to commit crimes. He has never made that claim. This feels like a blog post on some lefty blog that would neutralize the most fundamental check on executive power, the recognition and the implementation of election results. Trump never claimed he's got unbounded authority to commit crimes, never once. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their counts vote. It's great. No one's asking you to do that, weirdo judges. Now, at the bottom, former President Trump's stance would collapse our system, they say, of separation of powers, and it would place the president beyond the reach of all three branches. No, it would not. All you would have to do is impeach him for stuff that's within the bounds of his office. This is a wild thing. Like, even he said that in his oral arguments. I already played the clip for you. Presidential immunity against federal indictment would mean that, as to the president, that Congress could not legislate, the executive could not prosecute, and the judiciary could not review. This is all like hyperbole. It doesn't even mean anything. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. That's good, because nobody's making that argument, so I don't know who you're talking to. Careful evaluation of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from general prosecution in general. And again, we're not saying that either. We're saying it's for his conduct while he was the president, or for immunizing former President Trump from the specific charges in this indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance. All right, and the last section from these lefty judges, the impeachment judgment clause, and this is one that we've been really focused on, saying the strongest evidence against Trump's claim of immunity is found in the words of the Constitution, they say, which I can't even believe they read it. But the impeachment judgment clause provides, it says this, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy those office, but the party convicted, ED, shall nevertheless be liable and subject to indictment, trial, judgment, punishment according to the law. So if you are convicted, then you're liable. Now they say that language limits the consequences of the impeachment to removal and disqualification, but it explicitly preserves the option of allowing other prosecutions according to law, right? So I think they just forgot about the convicted part of this. The language limits the consequences to removal and disqualification. Like, because this only limits you to removal, it shall not extend further than to removal from office or disqualification. I can't even believe these people know how to read, I gotta tell you. So they're saying, well, that language limits the consequences to just removal and disqualification, which is true because it's Congress. But then after they are convicted, then they're nevertheless liable to other types of prosecution. Okay, it preserves that according to the law. So former President Trump agrees that the impeachment contemplates and permits the prosecution on criminal charges. He argues that such a former president must first be convicted, the ED. There, they got it. In other words, he asserts that under the clause, a former president enjoys immunity for any criminal acts committed while in office unless he is first impeached and convicted by Congress. Accurate. Now, under that theory, he claims that he is immune from prosecution because he was impeached and acquitted, not convicted, with the ED. By taking that position, former President Trump potentially narrows the party's dispute to whether he may face criminal charges, in this case consistent with the impeachment judgment clause. If the clause requires an impeachment conviction first, he may not be prosecuted. But if it contains no such requirement, the clause presents no impediment to his prosecution. So they're just going to read it out. They say Trump also concedes implicitly that there is no absolute bar to prosecuting assertedly official actions, which is weird because like 20 pages ago, they said that he was making those claims, right? They said that up there, Trump claiming he has absolutely immune, but now they're saying he's not. Now he argues elsewhere in his brief that it's same and closely related. So they're trying to determine what is an official act, right? You got to be within the confines of official acts, the outer perimeter, as they say. So you've got like clear stuff, which would be like, a State of the Union, like giving the State of the Union. Okay, that's like, no one's going to charge you for that. But here, challenging an election, like they say that's at the outer end. And so maybe that is official. If it's outside the hula hoop, it's not official. If it's inside, it's official. They say Trump was impeached and he was acquitted for the same and closely related conduct to this indictment. They literally charged him with insurrection in the Senate. They didn't do that here. And he agrees that if he had been convicted by the Senate, he would not be immune from prosecution here. They finally got the argument now. Thus, he concedes that a president can be prosecuted for broadly defined official acts if he actually is impeached. Great. Now, the impeachment judgment clause is focused solely on those who are convicted by the Senate following the House impeachment. The first part of the clause limits the penalties that can be imposed because it's Congress, right? They're not a prosecutorial office. Judgment in these cases is limited to removal. Now, the second part makes clear that the limited consequences do not immunize him from criminal prosecution. We got that. But in Trump's view, however, the word convicted in the second phrase implicitly bestows immunity on presidents who are not convicted. Right. Based on negative implication. They got it correct. He asserts that the impeachment judgment clause presupposes that a president is not criminally liable absent a Senate conviction. Now, other courts have rejected this tortured interpretation of the impeachment judgment clause. What other courts? Claiborne case. And they're talking about federal judges there. Okay. It's like, what cases are you talking about? Okay, this is a case of first impression. So why are you leaning on other cases from other districts that don't involve presidents? Now, moreover, former President Trump's interpretation runs counter to the text. The force of any negative implication, it depends on the context, they say. So here they're going to give us some analysis. Good. Explain this in themselves. Let's see. To begin, former President Trump's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant criminal immunity in the Constitution. And so if they wanted to give him immunity, they would have just wrote it in there. Oh my gosh. Yet they chose not to do it because they did write it in there. It's called convicted. They didn't think they'd have to explain themselves to moron DC judges. The impeachment judgment clause merely states that the party convicted shall nevertheless be liable. But the text says nothing about non-convicted officials, right? So you have to read that in. Former president's reading rests on a logical fallacy, saying if the president is convicted, he can be prosecuted. But it does not necessarily mean that if the president is not convicted, he cannot be prosecuted, which serves their argument, obviously. The whole point of that provision is to have a constitutional check, a safeguard, to make sure that it is apolitical, okay? If both parties agree, both houses agree, then there was something really bad that happened. And if not, then it doesn't open the floodgates. Like, if you can just do whatever you want with this, if it doesn't matter either way, why'd they put the whole provision in there at all? Does it mean anything? Does convicted mean anything at all? If you just say it means nothing, because you're saying it means nothing. So the text of the impeachment judgment clause reflects its purpose. It's to allocate responsibility between the legislative and the executive branch for people who are responsible for misconduct. Bunch of copying and pasting here, saying the framers chose to withhold such broad power from the Senate because they're not the executive. They are not the executive branch, specifying instead that the Senate could impose only political and not ordinary criminal punishments because they're the Senate. Now, the framers wish to make clear that a president would still be liable to prosecution. We know after he is convicted. They're going back to the Federalist page. So, okay, we've read enough of this stuff at this point. Like, you know what the arguments are, and you can just pick and choose, which is exactly what they're doing. Now, as the Office of Legal Counsel noted, more copying and pasting, and in short, the framers, they say, intended impeached officials to face criminal liability according to the law. In short, then, the framers wanted impeached, doesn't have to be convicted, just if you're impeached enough is alone. They pull out this quote from Hamilton, Federalist 69, says the President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes, then removed from office, and would afterwards then be subject and liable to prosecution. Now, Trump focuses on the words afterwards, which matches convicted, but they go to the English dictionary and they say, well, it's, they read the dictionary. Okay. Other historical evidence also supports our conclusion. Edmund Pendleton, president of Virginia, of the Virginia Ratifying Convention. He wrote some stuff about this. And in drafting this, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that a subsequent prosecution would not be barred if you are convicted, as we've been saying this entire stinking opinion. They give us some more. They say, finally, practical considerations and practical consequences of Trump's interpretation demonstrate its implausibility. The impeachment judgment clause applies not just to presidents, but also to everyone else. Thus, his reading would prohibit the executive branch from prosecuting current and former civil law. So they just make it overbroad then. All right. If we give it to Trump, we got to give it to everybody. And then the whole world, now everybody's going to go murder everybody on the streets. Even if there is an atextual basis for treating presidents differently, which there is, from subordinate government officials, which there are, his proposed interpretation would leave a president free to commit all manner of crimes with impunity, so long as he's not impeached and convicted. Well, if he's committing crimes, just impeach him. Former President Trump's interpretation Constitution also would permit the commission of crimes not readily categorized by things that are impeachable. And if 30 senators are correct, basically he could just, hide and then leave office. Now, he also talks about double jeopardy. He says, alternatively, this is double jeopardy. I've already been tried once on this. As we've discussed, the impeachment judgment clause addresses only convicted parties. It does not address the consequences of Senate acquittal. So in other words, if you are acquitted, they can still punish you if they don't like you. Now, for the reasons already stated, this does not bar prosecuting Trump because the clause simply doesn't speak to it. It's a negative indicator there. But the weight of authority supports our claim. Since it doesn't speak about it, right? They don't want to read into it. They want to go get out a bunch of other stuff. And they say under precedent that interprets double jeopardy, former president and Trump's his impeachment, it does not bar subsequent criminal prosecution for two reasons. One, there were no criminal consequences from the impeachment, and the indictment does not charge the same offense as a single count in impeachment. Wow. So the impeachment was insurrection. Jack Smith was too cowardly to charge him with insurrection because he knows he can't prove that. But it is now not double jeopardy because it's not the same charge, is what they're saying. An impeachment is not criminal. So in order for it to be twice charged for the same crime, it's also got to be a crime. And so Trump's acquittal in the impeachment trial makes this point. A bunch of senators acquitted him not because of the offense that was even charged. They said, we have no power to convict him. I don't care what their explanation was. It wasn't enough to overcome the burden. Now, in light of very different procedures, right? A criminal trial is different than a political trial. One's in a court of law, one's in the clown house of Congress. So they say impeachment is not a criminal process and cannot result in criminal punishment. I think that's probably the best argument that they've got in terms of case law in this whole filing, but that's it. Now, Blockberger says, you look at the elements of the crimes, and if they match up, like 3 elements match these 3 elements, and 1 element matches this, but 1 element in each crime is different, you can be charged with both crimes. So here, it's not the same offense. Okay, one's insurrection, the others are conspiracies to obstruct official proceedings, so they're not the same. Now, Trump does not dispute this analysis, and so it's not the same crime, it's not the same conduct, and so double jeopardy doesn't apply. And I think, like as I said, double jeopardy principles are pretty hardened, and we know what jeopardy is, that's codified. And so I think that impeachment does not protect against that, but you got to be convicted in order to bring that second charge. So he would still be precluded under the first step of that analysis. But they say in this so ordered opinion, not signed by any of those judges, they say all of this analysis, we have balanced President Trump's asserted interest in executive immunity against the vital public interests in favor of allowing this prosecution to proceed. And that's really the whole point of this whole opinion. That's it. Okay. They did a balancing test. The rest of this is backfilled, copy and paste case law, where they're not even logically consistent. Like, they know what Trump's argument is, but they spend the first 2/3 of it arguing against a straw man, a made up argument. Trump says, hey, he's absolute immunity to murder Navy SEALs. He never said that at all. They get down to this section. We conclude that concerns of public policy, especially as illuminated, compel the rejection of his claim, and immunity in this case. It's just their public opinion. It's their public opinion. It's their public interest. It's not ours. It says, we also have considered his contention that he's entitled to immunity for official action that he took, a contention that is unsupported by precedent. And finally, we are unpersuaded by his argument that this prosecution is barred by double jeopardy. And so accordingly, Judge Chutkan and her decision is affirmed. Big surprise. We're not actually surprised at all. We know this was coming, but now it's up to the Court of Appeals, to the Supreme Court. And this is a fun footnote. They say, by the way, amici, former Attorney General Edwin Meese and others, they say Jack Smith is invalid. And looks like they're not really going to address this. They say no statute authorizes Jack Smith, and he's a principal officer who must be nominated by the president and confirmed by the Senate. But we generally lack jurisdiction to consider issues that do not independently satisfy the collateral order doctrine. This is a great question that came up on our locals this morning. In other words, can this disqualification argument go in front of the Supreme Court? And I think the answer is yes, if they want to hear it. Because the Appointments Clause issue was neither presented nor asked to be decided by this district court, there is no order on the issue that could even arguably constitute a collateral order for us to review. So, right, Supreme Court has original jurisdiction, like they're SCOTUS. They can do whatever they want and just craft rules. But this court is saying we can't. We can only really take what Judge Chutkan gave to us. So additionally, the exercise of jurisdiction would be improper, assuming without deciding that even the jurisdiction is ever available in criminal appeals. So we would not be able to handle that at all because this, file that in a different case. So that issue is going to be curious to see if that's addressed at the Supreme Court. And of course, the Supreme Court, they have oral arguments in 2 days from now. So make sure, my friends, you're subscribed here because we're going to be covering that and unpacking all of this. But immediate impressions were, this is not what a lot of people on the left are saying. They are screaming about this huge victory for the left. Yeah, this anchors in the constitutional decision and so on. You know, and they're saying it's going to either be rejected by the Supreme Court or the Supreme Court is going to accept it and then affirm this. I don't think that's either one of those is true. I think there's a lot of bad logic in here. They're even inconsistent in their own analysis. So that is the full opinion. Now, another question that's coming up is about what is this going to do to the timing? And this also came out simultaneously. We got some reaction to this. This case, they said it came to be heard and it's been ordered and adjudged that the lower case is appealed and affirmed. They say, though, the clerk is directed to withhold the issuance of the mandate. Okay, so this has to go back down to Judge Chutkan, but withhold it through February 12th. And as soon as Judge Chutkan gets it, she's scheduling a new trial date and this thing's back on track. If within that period, Trump notifies the clerk that he's filed an application with SCOTUS, then we're going to stay that pending what happens with SCOTUS, pending the filing of a petition. So as soon as Trump files this on the 12th, it stays everything. It's not going to result in the withholding of the mandate. So if he asks the full court to hear it, too bad. Chutkan can still keep the train back on the track. Now, the filing will not result in the withholding, but if they grant a rehearing en banc, then they will recall the mandate if the mandate has already issued. Okay, so if the full court takes it, then they'll stay it again. So that's what happened from the Court of Appeals, and there's questions about that. What is the timing going to look like? Kyle Cheney, he writes from Politico, covers this stuff pretty aggressively. He did some calculations for us. He says, all right, the DC Circuit Court took 55 days to take up the case. December 13th, they resolved it on the 6th. If SCOTUS goes at the same pace, about 2 months, and rules the same way, that would mean we get a SCOTUS decision in April. Chutkan says that she's going to give Trump the same amount of time to prep. So if we go December to April, how many months is that? Then we say, okay, we're back in April. So December, January, February, March, April, that's 5 months. We're back in April, and then we get another 5. Woo, so that says we could be putting that back into late July or early August for a trial date. And we already heard Judge Chutkan, she's ready to go. I think she's ready to have a trial at that time. Jonathan Turley also had a similar comment on this. Says, let's crunch some numbers on this. Says Trump can seek corrections in the short term, but even without a correction, he's got 45 days to seek an en banc. But they don't care about any of that, right? He then has 90 days after the en banc is rejected. They're going to keep this thing on track, right? But let's say Trump appeals that issue. So even without factoring in time for the review for the circuit, Trump could extend this as 135 days, absent a successful move to expedite by Jack Smith. The 90-day period would put the petition into May. Any rejection of appeals without an expedited calendar puts this into the summer. He says that is without delays or a successful grant by the DC Circuit, unlikely. Certain. Like what happens if SCOTUS just says that's good enough for us, we don't want to deal with it. And that's my biggest concern on this whole thing, is that the Supreme Court also does this. Well, we're not going to see this problem again. Okay, if they're not going to see the problem again, they're like, well, we'll just let that one stand. We just decline to hear it. Trump gets prosecuted. They just let the people, deal with it there, and saying this issue's never going to repeat itself because they're not going to do this to other presidents. We'll see what the court does. Now, the question is why SCOTUS would suddenly see a need to accelerate all this. And Turley's basically saying he's not so sure that a trial is going to happen before the election. And I'm not sure if it is either, but let's see what else he said. He said the DC Circuit adds a wrinkle on scheduling by saying that Trump only has until Monday, the 12th, to file with SCOTUS. The standard rules allow Trump 90 days. So why'd they only give him a couple days, 1 week? If he doesn't, then the mandate returns back to the district court. Judge Chutkan restarts all this. Then there will be emergency motions, maybe. And, the whole thing is, here's what his conclusion is. If not months, if everything breaks for Smith on the calendar, he could still secure a pre-election trial, but he's facing diminishing odds. And for some reason, I feel like they're going to squeeze it in. I feel it. Here is what Shipwreck Crew said. He said that, yeah, they're singling Trump out. And of course, we know that. Even the DC Circuit is doing it. Saying, I now suspect that some judges might again be unhappy about the procedural games that the DC Circuit Court of Appeals was making in altering the rules. Rather than follow the rules that we heard from Turley, they gave Trump 6 days to seek a stay from SCOTUS. And they state, unlike every other case, that filing a motion for rehearing won't delay the issuance of the mandate. But for every other case, it does. How come they're doing that now? It says, I think this might land flat, just like Smith's efforts to bypass the appeals court. Like, courts are not going to be happy about that. Why don't the ordinary rules ever apply to Trump, just like everyone else? Well, because he's Trump. That's from Shipwreck Crew over there on X. And we had some reaction. Mike Johnson got asked about this very briefly as he was waddling out of Congress with the rest of our leaders, so-called. And here's what he got asked about from CNN.
The appeals court today just ruled that President Trump does not have immunity. Do you think that he deserves total immunity from anything that he's done in office?
I haven't seen that development. Was that this morning?
Yeah, they just ruled this morning.
I believe that they've been after President Trump for partisan political purposes. I think that's obvious. And we call it lawfare, and I think there's no other way to describe it.
How did you go about picking your impeachment?
So lawfare, I think that's accurate. We also have this gentleman who is over in Washington, D.C., explaining his take on this. And this is a representative called John Rose saying Trump had every right to contest this election. And he's right about that. That's his job.
The fact is, President Trump had every right to peacefully contest the results of the 2020 election. Hillary Clinton did it. So did many of my Democratic colleagues in 2000, 2004, and 2016. The rules are clear and simple. They're written in Article 2, Section 1 of the Constitution and in the Electoral Count Act of 1887. It's how our process works. As a former practicing attorney, I can say there isn't a single shred of evidence that points in the direction that President Trump participated in an insurrection. The fact...
No, there isn't. And when they use that word, they throw it around. You really want to be clear what that means. Like, what did they have weapons? How long did it last? Were there casualties there? Was there an actual, seizure of property and control for a certain period of time? What was it that really led you to believe that there was an attack on the country, honestly, rather than a short riot that was instigated by the feds? Well, Trump has an obligation to take care of the country under the constitutional provision that obligates him to do that. Challenging a rigged election is part of that duty. So here is what Trump said in response to this. It says, as president of the United States, a president must have full immunity in order to properly function and do what has to be done for the good of the country. A nation-destroying ruling like this cannot be allowed to stand. If not overturned, as it should be, the decision would terribly injure not only the presidency, but the life, breath, and success of our country. A president will be afraid to act for fear of the opposite party's vicious retribution after leaving office. I know from personal experience, because I'm going through it right now. It will become a political weapon used for election interference. Even our elections will be corrupted and under siege. So bad and so dangerous for our nation. Save presidential immunity. And so I'm sure Trump will be appealing this. Question is when, what's going to be inside. We're going to be here to continue to cover this, my friends. They are pulling out all the stops, and this is not a surprise, right? We knew that these judges were going to vote accordingly and rule accordingly. Just, look at them. But that is what happened here. They are not even being honest about the arguments that are even being made. They are showing us who they are, and I'm looking forward to watching it all crumble around them. Their arguments are not even good. It's going to be fun to continue to unpack them. I hope you join us as we do, my friends. Thank you for being here. Don't forget to subscribe wherever it is you're watching this. We got a bunch of links down in the description below, including our lodge, our Watcher Lodge, watcherlodge.com. We got a bunch of activities coming up in February. We'd love to see you join us. We got our survival squad build out. We've got a scanner unboxing for some over the airwaves monitoring. It's going to be fun. We've got a Zen wellness workshop that's going to be a lot of fun. So come check it out. Come join us, all free for the first 48 hours when they're live. So come and join us. Watcherlodge.com. Links are in the description. And if you want any PDFs, you can find those at robertgovea.com. We're going to see you right back here on the next one, my friends.